Hello everyone, my name is MadelineBoggess. Today I will be presenting to all of you my chosen law case for this course, ATE 3515, Legal and Ethical Issues in Veterinary Technology at St. Petersburg College for the Bachelor's of Applied Science Veterinary Technology program. My case is titled, The American Society for the Prevention of Cruelty to Animals versus the Ringling Brothers and Barnum and Bailey Circus. It was classified as a federal law case. The hearing for this case took place at the United States District Court, located in the District of Columbia, in the presence of Judge Emmett G. Sullivan. The plaintiff party was the American Society for the Prevention of Cruelty to Animals, also known as the ASPCA, and the defendant party was the Ringling Brothers and Barnum and Bailey Circus, which is under Feld Entertainment Incorporation, or FEI. The ASPCA is a non-profit organization dedicated to preventing animal cruelty. The American Society for the Prevention of Cruelty to Animals was joined along with the Animal Welfare Institute, the Fund for Animals, Tom Ryder, and the Animal Protection Institute. The Animal Protection Institute was not part of the plaintiff party until October 27, 2005. Tom Ryder had been a former employee for the Ringling Brothers as an animal handler. He had witnessed firsthand how these animals were treated. Ryder had a deep respect and love for the elephants and was very disappointed in how they were treated. He noticed how it affected the emotional and behavioral health of the animals negatively. He would work and spend time with these animals again, but only if they were in a safer environment. The Ringling Brothers and Barnum and Bailey Circus is an American traveling circus company. They are well known as the greatest show on earth. Feld Entertainment Incorporation owns many traveling shows in addition to the Barnum and Bailey Circus. Because the Ringling Brothers and the Barnum and Bailey Circus is a trade name, the FEI is considered the main defendant of this case, even though it differs from the title of it. Now we will go into some of the facts about this important federal case. During this case, the plaintiff party, the ASPCA, filed a lawsuit against the defendant party, making an allegation that they were committing abusive acts against the Asian elephants in their possession on a routine basis. These acts included beating them, chaining them for extensive periods of time, and hitting them with sharp objects like bullhooks. It also included removing baby elephants from their mothers too early and forcing them in inhumane ways to become submissive to the elephant handlers. This allegation was made under the citizen suit provision of the Endangered Species Act. All of these actions were examples of violation of the take provision of Section 9 of the Endangered Species Act. On September 5th of 2006, the defendant filed a motion for summary judgment to the court. They pointed out that the elephants involved in their business do not meet the claims of the plaintiff because they fall under either one of two categories. The first of these categories includes the individual elephants that would be considered part of the pre-act species exemption, or, in the other category, the individual elephants that have been bred in the country of the United States of America, where they are valid for the CBW, or captive bred wildlife permit issued by the Fish and Wildlife Service. But what is the Endangered Species Act? Now for some background information on the Endangered Species Act and the details that would have been considered pertinent to this case. The Endangered Species Act was established on December 28, 1973, to provide protection to species listed as threatened and endangered. It is inclusive of fish, wildlife, and even plants. Asian elephants, which are used in the Barnum and Bailey shows, were registered as an endangered species as of June 14, 1976, according to the U.S. Fish and Wildlife Service. The take provision is described as to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture or collect, or to attempt to engage in any such conduct. In addition to the take provision, the Fish and Wildlife Service further defined harass in this section as an intentional or negligent act or omission which creates the likelihood of injury to wildlife by annoying it to such an extent as to significantly disrupt normal behavioral patterns, which include but are not limited to breeding, feeding, or sheltering. However, for captive wildlife, this excludes animal husbandry procedures that meet or exceed the minimum standards for facilities in care under the Animal Welfare Act, breeding procedures, and provisions of veterinary care for confining, tranquilizing, or anesthetizing when such practices, procedures, or provisions are not likely to result in injury to the wildlife. The term harm in Section 9 is defined further as an act which actually kills or injures wildlife. Such an act may include significant habitat modification or degradation, where it actually kills or injures wildlife by significantly impairing essential behavioral patterns, including breeding, feeding, or sheltering. With this information at hand, it brings us back to the case. After submitting the motion for summary judgment by the defendant, the FEI, the court made a decision that the pre-act exemption would not protect the FEI from the taking violations held under the Endangered Species Act. But since the citizen suit provision was used to claim these allegations, the court discovered that the captive bred wildlife permit that belonged to the defendant could not be challenged by the plaintiff party. The defendants also presented a motion that was considered by the court that would not allow the plaintiffs to use the information they had gathered from discovery to be released to the public. The defendants supported this motion by touching on the reason for discovery. This included an advisory to the court to not take advantage of discovery just for publicity reasons. Despite this, the court did not follow through or agree with the defendant's request. The defendants also made a motion for leave to amend answers to assert additional defense and counterclaim. This counterclaim referred to a potential scheme made by the plaintiffs, including Tom Ryder, to swindle the FEI of their income and remove Asian elephants from the Barnum and Bailey Circus entirely. This too was denied by the court. After a 6-week trial on March 18th of the year 2009, the defendants made their closing statements in front of the court and its judge, Emmett G. Sullivan. Even after the closing arguments made by the defendants, the court proceeded to provide an opinion. This occurred on December 30th of the year 2009. They became in favor of the defendants' party because none of the plaintiffs had been able to stand to justify their allegations. Tom Ryder, in particular, had not been able to provide evidence of his claims of how the elephants had been treated. The court came to the conclusion that Tom Ryder had been paid to be a plaintiff to this case. Interestingly enough, they also found out that Tom Ryder had been financially supported by animal advocacy groups for the past decade, and this made his integrity to his position on the case questionable. The Animal Protection Institute could not provide support for their claim with any information. In conclusion of the case, the court was able to accept only part of the summary motion, which was the elephants involved with the captive bred wildlife permit issued by the Fish and Wildlife Service, while the other part was denied, which were the pre-act elephants. For the final part of my presentation of this federal law case, I will provide my thoughts and analysis regarding the situation. As someone who is part of the animal healthcare field and has loved animals their entire life, I am 100% against cruelty to animals and have zero tolerance for it. While I know that this case involved the Asian elephants that were owned by the Ringling Brothers and Barnum and Bailey Circus, I also wonder why it did not include other species. If it is true that they were abusing these pachyderms, then who is to say that they don't treat other species in their possession in a similar fashion? Perhaps if the plaintiffs had alleged a claim that included more species variety than just the Asian elephants, then there would have been a wider range of evidence to have been discovered to support their statements. I disagree with the pre-act exemption law that excludes the elephants from the taking provision made under the Endangered Species Act. And I disagree with the captive wildlife permit that the defendants tried to use in this case to exclude the Asian elephants born in the United States of America from the taking provision. Rights of animals should be extended to all the individuals of the species, not just the subpopulation. These are the references I used during the creation of the presentation for the case, the American Society for the Prevention of Cruelty to Animals versus the Ringling Brothers in Barnum and Bailey Circus. I hope you enjoyed listening to my presentation and learned something from it today. I thought it was interesting to read about and important to know about since the history of animals and circus attractions is prominent in animal welfare history.